The goal here is I want to maximize my benefits. And that's the VA's goal too, maximize the benefits.
This is the moment I've been waiting for a long time. A big win is occurring in the courts right now for veterans, particularly on how your backdated pay for benefits is paid out. This could help all of us. We're going to get into exactly what happened and how this affects you next. I'm Jordan Anderson with VA Claims Academy. Let's talk about it. So this is a landmark decision in the case. The VA is getting sued. It's the case of Chisolm v. Collins, and a woman by the name of Jenna Zelmer, who is the attorney representing Chisolm Kilpatrick law firm, has argued, and it kind of exposed what we veterans have already known. Here's what happens. Tell me if this sounds familiar. You apply for your VA disability increase, let's say, and you're waiting 6 months. Things are going pretty well. You have a well-developed claim, your personal statements, all this evidence. And 6 months later, you get a letter in the mail. And that letter essentially says, you didn't use the magic form, And that's so frustrating because, first of all, why didn't you tell me 6 months ago? Secondly, the VA asks you, hey, do you disagree with your previous decision? Or is this a new claim? Most of us who are applying for an increase are saying, yeah, hey, I disagree with the decision, the rating decision, hence why I'm applying for the increase. Well, the VA is saying essentially, confusingly, well, no, you're not actually disagreeing. We're actually agreeing to disagree, which is different, so wrong form. It's so confusing. So at that point, it's just like you throw your hands in the air. It's okay, VA, what form do you want this on? And you give up half a year of backdated pay. Here's why that can be so valuable. We just had a client just this past week, it's not super rare, as you can see on screen right now, who received backdated pay after going through VA Claims Academy, being a premium member, and received 6 figures tax-free of backdated pay. And this happens from something called continuation of pursuit, okay? This means that if you keep your claim alive, basically, within 1 year, you're doing a supplemental claim. Okay, then you're doing this. You have new and relevant evidence. You're keeping that claim in the air. You're continuing your pursuit, which is something that we try to ensure for clients specifically for that reason, because you can get life-changing backdated pay if this is satisfied. But the VA tries to play games with the amount of forms, and it's technically not the right form, even though we knew exactly what your intentions were. And this is what the judge brought the hammer down on them. This is going to be massive moving forward, because no longer is it going to be this confusing process of, hey, actually applying for an increase isn't you disagreeing, we're agreeing to disagree. It makes no sense, right? You're disagreeing with the decision. Hey, I'm intending to apply for an increase. It's clear as day. If it was the wrong form, technically that's fine, but it shouldn't disturb your intent to file date, which again is that date that you get backdated pay to. This has been harming veterans to the tunes of tens of thousands of dollars, really, because each and every month you can be, getting $4,000, maybe $5,000 per month even, a special monthly compensation, and that adds up. Let's dive into the specifics of what this court case actually says. Now, mind you, the changes that this is going to take place, the changes moving forward, aren't going to happen immediately. There's going to be some things, the winds of change at the VA, you've heard me say, are blowing very hard right now, and this will take a while to set into place. However, this is massive for veterans. I'm going to play for you at the end of this video some of the actual court case so you can see this laid out in terms of what you're going to see the gentleman on the right-hand side is going to be arguing on behalf of the VA, and then you're going to see the panel of judges at the bottom there. But moving forward, you can hear the judges clearly say, hey, we get it. You have your separate forms. It's pretty confusing. You could hear the judges even asking questions like, okay, well, can you do a supplemental claim form for an increase and to disagree with the previous decision? So they know that it's confusing, and the judges are asking, hey, wouldn't it matter what the context is? Doesn't it matter what the intention of the veteran is? And that's the bottom line. This is kind of signifying what I think is going to be ultimately the golden age of VA claims, because we're moving from this, red tape process where it has to be to the letter and wrong form, to where the intention of the veteran matters. the VA is implementing lots of automation, lots of artificial intelligence into their ratings process. And ultimately, that's what's kind of declining a lot of ratings because, hey, if it's the wrong form, the system just rejects it automatically. However, with this implementation, I think these systems are going to be upgraded to where it's going to be much easier. Okay. So right now we help clients out with, hey, make sure it's using this form. If you're doing this, make sure you're using this form if you're doing that. And that alone can save you tens of thousands of dollars. But I think moving forward is going to be even easier. And if you have been, let's say this has costed you backdated pay in the past already, and this new law changes, I'm very curious to see if there is going to be any route forward for recourse, any route forward for maybe doing an appeal to claw back some of that backdated pay. That is yet to be seen, and I would like to see that implemented, but that's just speculation for now. So I really hope that you like this video. Here is the actual court case. You're going to hear these arguments. I want to hear your thoughts on what you think for yourself.
He puts in for a higher rating, loses that, gets a rating decision that doesn't give him it, seeks higher level review, loses that, and then says, well, in my continuous goal to maximize my benefits, I'm going to say I want TDIU for these very same disabilities, radiculopathy and tinea pedis. How is that not? How is that not a supplemental claim? Setting aside it's not on the right form. How is that not? I'm challenging the denial of my increased rating, and I'm seeking a new theory.
Your Honor, there's no indication that he was challenging the denial of the increased rating. The indication is that he sought a higher rating. With regard to a supplemental claim filed within 1 year, form filed within 1 year, there's an indication that the veteran is seeking review of a prior determination or adjudication. With regard to filing of the TDIU claim, the veteran is seeking a higher rating based on individual unemployability. There's no indication that he sought to continuously pursue or otherwise challenge the prior adjudication. So when you have, and again, this is our position is that this was a tactical choice. So for example, the veteran could have received a TDIU rating or filed an initial claim, an initial increased rating claim, received a 1 year look back, and potentially that kind of afforded him an effective date potentially earlier than what he may have been entitled to under just viewing the individual underlying service-connected disability claims. So we only have an indication of what the veteran desires through the primarily through the form submitted. Also, the language of the form, the specific TDIU application form, indicates that the veteran sought to add his TDIU claim as part of his underlying left knee claims and lumbar spine claims, because there were no tinea pedis or right lower extremity neuropathy claims on appeal at the time of the filing. So regardless of whether we look at the beyond the four corners of the document or whether we look at the actual document that was filed, there's no indication that the veteran sought to continuously pursue any previous challenge, any previous denial of the same basis. Instead, it appeared that the veteran filed a new initial increased rating claim based on his desire to seek a higher rating based on his individual unemployability. Because again, maybe he was unable to establish increased ratings based on the evidence of record meeting the diagnostic codes for each of the underlying conditions.